Hello, my name is Steve Miller, DivorceDeli.com, the online Florida law firm. Legal work, all legal work, should be done by lawyers, in my opinion. What follows is an example of what can happen when you try and represent yourself in legal proceedings. This case involves two people who were divorced in 2006. They entered into a marital settlement agreement. Each party waived alimony, meaning that there was no alimony from the husband to the wife and no alimony from the wife to the husband. 3 months after they divorced, they executed a document which the husband thinks entitles him to $3,000 per month from the wife. He tried to enforce that document in the divorce proceedings, and what follows is a result of trying to represent yourself in legal proceedings. Take a look. Call me, Steve Miller, DivorceDeli.com, the online Florida law firm. Thank you.
Where do we stand on the motion to dismiss, sir?
Your Honor, as I stated in my pretrial statement, and it's not an issue, there was a final judgment of dissolution entered back on December 11, 2006, which incorporated the parties' final marital settlement agreement and incorporated that marital settlement agreement into the final judgment. As you will note in Section 2 of the marital settlement agreement, there was a mutual waiver of spousal support. The final judgment entered by the court on or about December 11th, which is also in the court file, was attached to my pretrial stipulation as Exhibit A, did not reserve jurisdiction with regards to a modification of alimony. Even if it did, it wouldn't have much effect because there is a waiver of alimony. And so the parties have the absolute right to waive alimony. They did waive alimony, and as a result of the court not having retained jurisdiction with regards to alimony, it has no subject matter jurisdiction to now modify the waiver of alimony. And for that reason, that portion of Mr. Hammond's petition should be dismissed with prejudice.
Mr. Hammond, you mean?
I'm sorry, Mr. Hammond, I'm sorry. I apologize.
To start with, Your Honor, I don't know how to, I'm not a lawyer, I don't know how to address his legal sites and their motion. The only thing that I would say is the final marital settlement agreement that we both signed and had notarized after the divorce was finalized also stated that this document be included as part of the final divorce decree. She agreed to that, she signed it. Now, I don't know that this is a enforcement action or not, but my original petition stated that it was, I don't know the exact words now, but that it was for award of alimony and I think something to do, maybe not the word enforcement.
Okay, this supplemental petition you're talking about is filed January 2008?
Yes.
Okay, let me review that real quick. Modification of final judgment, award of permanent alimony, and to compel the sale and refinancing
Compel, correct.
of the marital home and states as follows. Action for modification of final judgment. Prior order, you talk about a second marital settlement agreement. Jurisdiction and venue. Okay. If I look here at, go ahead, sir, you can have a seat. If I look here at the marital settlement agreement that you filed October 12th, 2006, it says, each of us forever gives up any right to spousal support that we may have. And that's a contract that Judge Monaco says the parties have voluntarily entered into a marital settlement agreement and each has filed the required financial affidavit. Therefore, the marital settlement agreement is filed as Exhibit A in this case and is ratified and made part of this final judgment. The parties are ordered to obey all provisions. Paragraph 6 is the court finds the parties have the present ability to pay. Support is agreed to in the marital settlement agreement as ratified and made part of this final judgment. the court reserves jurisdiction to enforce this final judgment, to enforce this contract here, signed by you and your wife. Do you have any evidence that makes this contract void?
Well, sir, the only evidence I have is the second marital agreement that we both signed and was filed with the court. Plus, sir, I would like to explain that when we filed that divorce on October the 12th and it was finalized on December the 11th, it was, I'm not sure our intention, but it was my intention to actually separate. I never wanted to actually separate from my wife.
Okay. This is a no-fault state, sir. You could be a cheater, a liar, and a skunk, and you could not object if your spouse wanted you to be divorced from them.
I understand, sir, but, and that, the only reason I signed those documents and initialized them, instead of going to court at that time, was that it was my understanding from her that neither one of us actually wanted to separate. The divorce was being filed for, only for legal reasons, so that I could allow her a spousal defense against the IRS and the liens that were on the property.
Okay. Go ahead and have a seat. Mr. Miller, I'm going to reserve on your motion to dismiss. We'll conduct an evidentiary hearing on the motion that's been filed for supplemental petition to modify. It will be confined to the marital settlement agreement, the order of final dissolution of marriage signed by the judge, and if any evidence is brought forward concerning the second contract signed by the parties that was never adopted by this court, and I'm telling you I've read this court file, then Mr. Hammond, you're going to have to show me some evidence why that needs to be considered in your supplemental petition here today. I can't practice law for you. You understand? We're confined to the four corners of these documents, unless you have evidence otherwise. So, do you have any other argument you want to make or witnesses you want to present, Mr. Hammond?
No, sir.
Do you have any testimony you want to provide regarding your second marital settlement agreement that you had filed by your attorney in January 2008?
The only testimony I have, Your Honor, is the testimony I just gave to you.
Mr. Miller, I just want to address this from looking at it within the four corners of the document. The one that was entered into by Ms. Hammond and Mr. Hammond on December 29th, and then filed with the Clerk of Courts January 7th. This appears, from the four corners of it, to be a housekeeping issue. It has nothing to do with alimony or support. How to divide up who gets what bills, who gets what accounts, who gets what insurance policies. It has nothing to do with alimony and spousal support, sir. And it was never ratified, adopted, or incorporated by the judge. It was just filed by your attorney.
Well, there you have it. Legal work, all legal work should be done by lawyers. Make no mistake about it. Doesn't matter whether it's a large issue or a small issue. In my opinion, legal work should be done by lawyers. If you have a family law need, call me, Steve Miller, DivorceDeli.com, the online Florida law firm offering low-cost, flat-fee legal services in all family matters throughout the state of Florida. Thank you.